Justice Gorsuch?
I understood the Office of Legal Counsel's memorandum to suggest that the Secretary, under the statute, had authority to put student borrowers in the same condition that they were in prior to the emergency, and that the nature of your argument is that that test is not met. Do you agree with the OLC's position and understanding of the statute, and how do you argue that it's exceeded that authority?
Your Honor, I disagree with most everything in the OLC opinion, but I agree with that part of the OLC opinion. I think it's right that that's what the phrase "no worse position" means. It means Congress was telling the Secretary he had the authority to keep borrowers near the status quo. But what we have here is a program that for 20 million borrowers is going to leave them without a single outstanding loan. That goes well beyond putting them back in the status quo ante. And for the other approximately 20 million borrowers that stand to benefit from this, their average debt is going to go from $29,000 to $13,000. Again, far beyond returning to the status quo ante.
And I understand the Secretary has considerable expertise when it comes to educational affairs. But in terms of macroeconomic policy, do we normally assume that every Secretary, cabinet member, as learned as they are, has that kind of knowledge?
No, we don't. When we're dealing with a nearly $500 billion loan cancellation program, this is squarely in the ken of Congress. Congress has the power and expertise to weigh the balancing competing fiscal implications, particularly at that scale. So this is something that's outside the Secretary's expertise.